Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers the First Amendment, recording traffic stops, and obstructing, and is brought to us by O'Shea Jackson's channel. Be sure to check out the description below and give them the credit that they deserve. In body camera footage posted to his YouTube channel on July 19, 2018, retired Army Ranger O'Shea Jackson stopped his vehicle to attempt to film a traffic stop involving a potentially stolen vehicle in Columbus, Georgia that was being conducted by several police officers from the Columbus Police Department.
You can't get this close, sir. If you want to get in front of my car, you can.
Right here,
sir, you need to go back over there, okay? Sir, you can go over there right now.
I don't have to back up.
Yes, you do. Okay.
Don't deal with him.
Sir,
I'm dealing with him right now.
You can go and step in front of my car and record all you want to.
This is my stop.
Sir, this is an investigation. You need to step in.
You're standing next to a stolen vehicle. You need to move.
You need to go back there, okay? You can go in front of my truck. That's fine.
I ain't going in front of your truck.
Sir,
go back there. Sir,
do what you need to do.
Sir, you need to walk in front of there,
We're
okay?
trying to tell you to get away from our
Do
seat.
what you need to do.
Sir,
If you want me to disarm
This is your
myself,
last warning. Get beyond our crime scene, okay?
do what you need to do.
Do it under. Put your hands on
Okay? Don't touch my camera.
We gave you multiple warnings to leave the scene.
you have any other weapons on you?
Say again?
You have any weapons on you?
No.
How hard is this? All you have to do is
Because
listen, man.
I'm able to.
Scott, can you get on this side?
Where I can hear.
You were
Sir,
not,
I can't hear
you're not
way
able to
back
be
there.
in
I asked you to step in front of. This is the crime scene right now, okay?
Like I said, I tried to move. If that ain't good enough, then
And I told you to step in front of my truck.
We're next to a stolen vehicle.
Scott, get on this
There's
side.
a man with a firearm who's not listening.
I'm legally armed. You don't have to know who I am. You don't have to know who I am. Hey, you good?
Right now,
we're getting a step back from this guy. No.
That's what we're trying to tell him.
Okay. What's going on, man?
Listen, man.
I'm just filming. That's all I'm doing. If you want to say
And I said you could film from back there.
I'm also supposed to be able to hear what I'm recording.
Mr. Jackson explains that he didn't step back as far as the officers asked him to because he is supposed to be able to hear what he is recording. In addition to establishing a First Amendment right to film the police in public in the performance of their duties, courts have also recognized a right to capture audio recordings of such interactions as part of the constitutional protections afforded to news-gathering activities. In the 1972 case of Brandsburg versus Hayes, the Supreme Court held that news gathering was protected by the First Amendment because, quote, without some protection for seeking out the new, freedom of the press could be eviscerated. However, the court clarified that, quote, it is clear that the First Amendment does not invalidate every incidental burdening of the press that may result from the enforcement of civil or criminal statutes of general applicability. The court has emphasized that the publisher of a newspaper has no special immunity from the application of general laws. Newsmen have no constitutional right of access to the scenes of crime or disaster when the general public is excluded. In more recent decisions, courts have held that the First Amendment protections that the Supreme Court has recognized for news gathering in general also apply to collecting audio footage of the police. For example, in the 2020 case of Project Veritas Action Fund versus Rollins, the First Circuit held that, quote, the First Amendment imposes at least some restrictions on the government's authority to bar the audio recording of police officers while they are discharging their official duties in public spaces. A citizen's audio recording of on-duty police officers' treatment of civilians in public spaces while carrying out their official duties, even when conducted without an officer's knowledge, can constitute news gathering every bit as much as a credentialed reporter's after-the-fact efforts to ascertain what had transpired. Several other circuit courts have reached the same conclusion and recognized the right to record the police in public, such as the Third Circuit in the 2017 case of Fields versus City of Philadelphia, where the court held that, quote, under the First Amendment's right of access to information, the public has the commensurate right to record, photograph, film, or audio record police officers conducting official police activity in public areas. Importantly, the 11th Circuit, which includes Georgia, also recognized the First Amendment right to record the police in its 2000 decision in the case of Smith versus City of Cumming, concluding that the plaintiffs in a Section 1983 claim, quote, had a First Amendment right subject to reasonable time, manner, and place restrictions, to photograph or videotape police conduct. Applying these standards, a court would likely conclude that Mr. Jackson had a First Amendment right to capture both video and audio while filming the officers, but also that Mr. Jackson's right to do so could be limited by reasonable time, place, and manner restrictions.
Okay, well, you are in the middle of what we're investigating right now.
I backed up.
And at this point, you have obstructed our investigation.
I backed up.
No, I told you to get in front over there multiple
I
times.
backed up. I don't care. Do what you do.
Okay.
You got guys are supposed to be able to be watched
And
heard.
and I told you
can't
you can
hear
go there.
anything from back there.
I'm sorry.
So that's the bottom line. The bottom line, I know what the law now. Conifer and Glick, they said.
Hey, Damien or Jacob, can y'all come over here? Because we got two different things going on.
What do you
All
call
right.
when you were right next to him?
Okay, when he said it was a stolen car, when he said it was a stolen car, I wasn't close to him. When he said it was a stolen car, then I said I will back up.
You were right. You came up right behind me. I asked you to step in front of my
I
vehicle.
said I'm not stepping in front of your vehicle.
And you have obstructed our
Oh, yeah, if I
investigation.
make a call. Do not do what you guys have to do. Just this stuff goes up to the cloud. So if you touch my video,
Sir,
then it's
I don't.
gonna be-
We're not. We have videos everywhere here. We're not
Okay.
worried about that. Okay.
Like I said, when he said it was a stolen car, I did back up a little bit further.
And I already told you multiple
And I
times
said
to step
I can't
in
hear
front.
back there.
I said, told you.
The
I'm
First
sorry. I'm
Amendment
sorry about
says
that.
I'm able to record you guys, and I must be able
You can
to hear.
record all you want to. I'm saying I asked you to
I
step in
must
front
be
of
able to
there.
hear. Do what you need to do.
Okay. Well, I asked you multiple times and you didn't do it
Do
at
what
all.
you need to do.
Let's go back here to the back to this car.
Okay.
What are you talking about?
Go ahead.
Okay, we're gonna
Sir, go
grab my
back.
camera.
I'll grab your camera.
What are you talking about? You must be able to hear. I do.
Yeah, I must be able to hear what's going on. The First Amendment says I can record a public figure.
And that's
Okay, when he was way over there, I was over there.
You can record, but I don't think there's anything in there about you being able to hear.
Conifer and Glick. It's 10 feet, but 10 feet is way too close.
Here, it appears that Mr. Jackson claims that the 2011 case of Glick versus Cuniff, the First Circuit case that first recognized the right of citizens to record the police in the performance of their duties, established a quote-unquote 10-foot rule for filming public officials and or police officers. While the court in Glick did not actually create a specific guideline for how close a citizen can be while recording the police, it did determine that an individual who was standing about 10 feet away from an arrest to film was acting well within the bounds of the First Amendment's protections. The court explained that, quote, Glick filmed the officers from a comfortable remove and neither spoke to nor molested them in any way except in directly responding to the officers when they addressed him. Such peaceful recording of an arrest in a public space that does not interfere with the police officer's performance of their duties is not reasonably subject to limitation. The same restraint demanded of law enforcement officers in the face of provocative and challenging speech must be expected when they are merely the subject of videotaping that memorializes, without impairing, their work in public spaces. However, it should also be noted that the incident that was being recorded in the Glick case occurred in a public park, not on the side of the road during a traffic stop, and it is possible that a court could determine that a larger distance between Mr. Jackson and the officers was appropriate in this situation. In the 2014 case of Garrick versus Begin, the First Circuit applied the Glick standard to filming a traffic stop, explaining that, quote, the circumstances of some traffic stops might justify a safety measure, for example, a command that bystanders disperse, that would incidentally impact an individual's exercise of the First Amendment right to film. Such an order, even when directed at a person who is filming, may be appropriate for legitimate safety reasons. After explaining the possible incidental impact of a general order to disperse, the court then clarified that, quote, however, a police order that is specifically directed at the First Amendment right to film police performing their duties in public may be constitutionally imposed only if the officer can reasonably conclude that the filming itself is interfering or is about to interfere with his duties. In this situation, the officers advised Mr. Jackson that he could continue filming, but ordered him to step back further away from the scene. Since courts have not established a specific distance requirement for filming the police, a judge could conclude that the order to move back was a reasonable safety precaution and not an infringement on Mr. Jackson's First Amendment rights.
I agree. So when he said this car was stolen, I moved back over here.
Sir, you came right here. I said, please go in front of my car.
And I said I wasn't going to do that, but I moved.
And that's why we're
You
here
see
right
my
now,
camera?
okay? That's why we're here right now.
Do you see my camera?
You moved about 5 feet.
Do you see? Is that 5 feet?
You were right here.
No, I was right here next to the door.
Okay, well, let's say 10.
That is not
8
that's,
feet.
Actually, that's 10
We're not
meters.
going to argue.
Okay.
Yeah, we're going to go to jail today for obstruction.
Okay.
Do you have someone come get your vehicle?
I sure do. I'll make the call.
Where, do you have your phone on your person?
No, it's in my car.
Do you know their number?
Yes.
You send me a call from my phone?
Sure.
Okay. Hey, Michael, can I put him in your car until we get one of our guys? Yeah, that's fine. You don't have to take him. We just got another transport on the way.
You can't, as long as I will guarantee you that somebody's going to come up on charges after this is because it's not interference when I'm filming. You can't say...
And I said that clearly. I don't have a problem if you film. I said you just need to get in front of the crime scene, and you need to get in front behind the crime scene. I told you that.
I understand.
And you said you were not going to do that.
I said I was not going to move in front of your truck, but I did move. It's on my camera.
I know, it's on my camera.
The officers inform Mr. Jackson that he is going to be charged with obstruction, a criminal offense that is codified in Section 16-10-24 of the Georgia Code, which states that, quote, a person who knowingly and willfully obstructs or hinders any law enforcement officer in the lawful discharge of his or her official duties shall be guilty of a misdemeanor. When interpreting this statute, it is important to note that it also creates a separate felony offense for resisting, obstructing, or opposing a law enforcement officer, quote, by offering or doing violence to the person of such officer. Accordingly, courts have taken a broad view on what constitutes misdemeanor obstruction, and as reviewed by the Court of Appeals of Georgia in the 2014 case of Johnson versus State, Georgia courts have upheld obstruction convictions for repeatedly refusing to obey an officer's instructions to calm down and step away while the officer was interviewing a person at whom the defendant was screaming and cursing, refusing to obey an officer's lawful commands to wait and back off, yelling and behaving confrontationally in combination with a refusal to sit down and remain in one place, and refusing to leave a home that was not the defendant's residence during a police investigation. Additionally, in the 2017 case of Lebus versus State, the Supreme Court of Georgia determined that there was sufficient evidence to support multiple convictions of obstruction against an individual for deliberately and intentionally disobeying an officer's lawful command to put away her cell phone, stop walking toward him, and show him her hands. Therefore, it is entirely possible that Mr. Jackson could be convicted of obstruction for failing to comply with the officer's orders to move further back to film if a court concluded that the orders were lawful. However, if the officers had simply ordered him to stop filming and he refused, he could only be convicted if the filming itself was interfering with the investigation.
Okay, absolutely.
Okay, well then we're clear on that. We're clear on that I told you multiple times to get behind my truck away from the crime
I said
scene.
I wasn't going to get behind your truck. Is it still on the camera?
You could still be...
I cannot hear right there.
Okay. Well, we're not going to argue out here.
Well, you're right.
As a result of this encounter, Mr. Jackson was arrested and charged with obstruction. Mr. Jackson stated that he represented himself in court and that, although he lost the case, the judge never told him that he was guilty. He was not assessed fines or court costs, and he was only required to do a few hours of community service. No public court records regarding Mr. Jackson's case could be located, and it is uncertain whether Mr. Jackson intends to take legal action following the incident. Overall, the Columbus officers get an A for making a legitimate effort to respect Mr. Jackson's right to record the stop, maintaining a calm and collected attitude, and for remaining within the bounds of their authority throughout the interaction. At no point during the interaction did the officers order Mr. Jackson to stop recording, and it is clear from the video that their primary objective in ordering him to step back was to create enough distance between themselves and Mr. Jackson to secure the crime scene. The Columbus officers told Mr. Jackson that he was within his rights to record them, and offered him an ample alternative to the location he was filming from, thereby adhering to the time, place, and manner restrictions established by the Supreme Court. Nothing the officers did violated Mr. Jackson's First Amendment rights within the context of a traffic stop, and it is not difficult to see why Mr. Jackson lost his case against the obstruction charge. Mr. Jackson essentially forced the officers to arrest him by refusing to obey their order to move to a safer location, and the fact that Mr. Jackson was armed at the time of this interaction only adds credibility to their commands. Although Mr. Jackson was lawfully armed, that does not dissolve the inherent danger presented to the officers that was introduced by the addition of an unknown individual carrying a firearm near a potentially dangerous traffic stop. The concepts of officer safety and civilian rights are often at odds with one another, but there appears to be a relatively prevalent consensus among the courts that traffic stops are far more dangerous than a typical police encounter, and it is not unreasonable for officers to take advantage of safety measures that have been examined and approved by the courts. I commend the Columbus officers for carrying out their duties safely and effectively and offering Mr. Jackson multiple opportunities to reconsider his position before making an arrest. Mr. Jackson gets a C- for disobeying what were likely lawful orders to move away from an active crime scene, misrepresenting the Glick ruling in an effort to justify his refusal to move, and for failing to do his due diligence before attempting to film the police in the course of their duties. While it is clear that Mr. Jackson has reviewed case law to some degree, it is also clear that his legal knowledge knowledge is somewhat cursory, and his misinterpretation of the Glick case was a major factor in his decision to disobey the officer's orders. When attempting to review and understand cases and jurisprudence, it is just as important to understand how the courts have interpreted laws and rulings within the context of other cases and real-life circumstances, as it is to consider the precedent set by the case. Different courts may interpret the same case differently depending on many factors, such as the circumstantial variables surrounding the case, the state-level precedent involved in the case, and the historical context of the case. And how a court will rule on any given issue is not rigidly governed by how courts have ruled in the past. As a self-proclaimed First Amendment auditor, Mr. Jackson took on a deeper societal burden to understand the complexities of the American justice system than the average citizen. And attempting to conduct an audit without taking the time to fully understand the legal implications associated with your conduct is reckless and irresponsible. One aspect of Mr. Jackson's approach that should be noted is that he was more than willing to express his grievances in court rather than on the street. And although he ultimately lost his case, he remained calm and cordial throughout the interaction and challenged the Columbus officer's conduct in the appropriate setting. While I commend Mr. Jackson for having the passion and courage to hold his public officials accountable, I would also caution him to take a deeper look into the jurisprudence surrounding the legality of filming members of law enforcement. Be sure to give your support to Mr. Jackson's YouTube channel. You can find a link in the description below. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.